Unit 4. Real Estate Contracts. A real estate ownership is not acquired automatically, but by entering into the land registry and based on a sale and purchase contract and on a permit for land registration. A real estate ownership can be acquired: 1. By legal transactions. 2. By a court decision or by another competent authority. 3. By inheritance. 4. By law. A real estate ownership is not acquired automatically but by entering into the land registry and based on a sale and purchase contract and on a permit for land registration. The permit for land registration may be an integral part of the contract, a special document, or may be contained in the proposal for registration. In such cases, the document or proposal for registration containing the permit must contain all the information required for the registration. The proposal for registration of the ownership right is submitted to the Land Registry Department of the competent municipal court according to the place where the real estate is located. It is also possible to submit an electronic proposal for registration in the Land Registry, regardless of where the property is located, through all public notaries in the Republic of Croatia and through attorneys who have requested such an opportunity. To register the ownership rights, it is necessary to submit a proposal for registration in 2 copies. Sale and purchase contract, original or certified copy. A certified permit for land registration of the seller, if it is not an integral part of the contract or the permit is not contained in the proposal for registration. Proof of citizenship of the buyer, a certificate of nationality, identity card, passport. A court fee of 250 kunas or evidence of exemption from a court fee payment. If the proposal for registration of ownership rights is not submitted within 60 days from the date of meeting the conditions for registration of these rights into the land registry or in the book of the deposited contracts, a 5-fold fee shall be charged. Once all the necessary documents have been submitted and the registration number has been received, the status of the case can be checked on the websites of the Ministry of Justice. The deadline by which the Land Registry Department of the competent municipal court is obliged to register the ownership rights in the land registry is not prescribed by the Land Registration Act. Items are usually dealt with according to the order they were received at the Land Registry Department. An energy certificate is a document that states the energy properties of the building, and it is made by authorized energy certification persons, energy certifiers. The document is valid for 10 years from the date of its issuance. The energy certificate of the building is issued for the building or its special part, for which energy is required to maintain the internal temperature according to its purpose, except for a building used to hold religious ceremonies or religious activities. Temporary building with a term of use of 2 years or less, an industrial plant, a workshop, and a non-residential agricultural building with small energy needs. A residential building that is used for less than 4 months a year. A freestanding building with a total usable area of less than 50 square meters. The investor or the owner of the building for which the energy certificate is issued is obliged to obtain an energy certificate before issuing the use permit unless otherwise provided by the law. The owner of the building for which the energy certificate is issued, or for its special part, is obliged to, before selling, renting or leasing of the building or its special part, obtain an energy certificate. Submit the energy certificate or its copy to the buyer or a lessee. Submit the energy certificate to a possible buyer or a lessee. In an advertisement for sale, lease or a rent of a building or its special part and which is published in the media, indicate the energy class of the building. When purchasing a real estate, it is usual to sign pre-contract, in which the real estate is defined by indicating land registry data regarding the real estate, cadastral municipality, particle number and land registry file number in which the property is registered, and the description of the real estate, apartment address, floor, apartment number, description of rooms it consists of and the total surface, the price, the date of the conclusion of the final contract and the down payment for the real estate. The down payment is agreed upon as a cancellation fee. If the buyer gives up, the seller keeps the down payment, and if the seller gives up, he has to pay the buyer the double amount of the down payment. The usual amount is 10% of the value of the property. The sale and purchase pre-contract must be notarized by notary public.